The light's terrible, I know, but I haven't been on in so long. I had to clip on the microphone and talk to you about the ongoing debacle with foreclosures, collections, and associations. This week we passed kind of a new milestone in my office. We've got about 3,300 mortgage foreclosure files we're defending or tracking on behalf of our association clients. That's about $1 billion worth of money down the drain. Now that'll probably come back up at maybe say 40 cents, 45 cents, 50 cents on the dollar, but it's really terrible out there. And what I'm finding is that mortgage companies, I'll use the term mortgage companies even though there's no such thing as a bank anymore. The banks are all owned by the federal government for the most part, and the entities that are foreclosing, a typical plaintiff is something like a Deutsche Bank as trustee for the Merrill Lynch Income Trust Fund Series 2006 XYZ 47QF3, and they probably couldn't even prove they actually own the mortgage they're foreclosing on, but that's all besides the point. 3 years ago, or even 2 years ago, when a mortgagee foreclosed, it typically took about 6-8 months to foreclose. Now, because of the crush of foreclosures, the fact that debtors are hiring lawyers to slow down the process, I'm finding that mortgage foreclosures can take anywhere from 8 months to 2 years to finish. And there's a logical reason behind that as well, because if the foreclosing plaintiff, the holder of the mortgage, takes title, it's got to pay either 6 months or 1% of the past due assessments or the value of the mortgage, whichever is less, or 1 year or 1% in an HOA, although that's subject to constitutional arguments, which I won't get into in this video. But the bottom line is, not only do they have to pay that, they have to pay ongoing assessments, they have to pay to maintain it, they have to pay to insure it, they have to pay property taxes, and the properties just aren't moving. So that puts my associations into a huge bind. And here's the Hobson's choice. Look it up if you don't know what it is. The Hobson's choice is this: does the association, which is already bleeding because it's not collecting assessments on that home, do nothing and wait for the mortgage company to foreclose, and meanwhile month by month essentially bleed to death? Or does it decide to start the collection process and foreclosure against the current owner, hoping that we can beat the bank to the courthouse steps? And if you watch my other videos, you'll know what I mean by that expression. But basically, as a general rule, an association's collection action and foreclosure can be concluded in 6 or 8 months. Which means that if you've got people who aren't paying, you might want to consider, and even if they're in mortgage foreclosure, you might want to consider going ahead and foreclosing anyway and taking title and renting the property, because that's the only way you're ever going to see any money out of the unit. The problem is there's no guarantee that you can't, that you'll be able to recoup what you spend. Now, in my case, when I handle these types of matters, even though I generally don't charge for my work as I go, and we advance all fees and costs until the foreclosure ends. When there's a mortgage foreclosure already going on, the odds are pretty good that we're not going to collect any money from the delinquent owner, which means that it costs me about $700 in cash to file the lawsuit, pay for service of process, the title search, the publication fees, etc. And what I've decided to do is offer my clients a $1,500 flat rate total collection process where there's a first mortgage foreclosure pending. That way the board can make a business decision and decide, well, is it worth it to spend $1,500 to try and go as fast as we can and as fast as the association can to take title to it and try and rent the property to recoup not only that $1,500 but whatever is being lost on a per month basis, or sit there and do nothing and just get foreclosed on left and right. When you add to that the fact that a lot of these properties that are in foreclosure have a tenant in them, and that the law provides that the association can require that the tenant put rent into the court registry, then we've really got a situation where the association can come out in reasonable shape, even in a first mortgage foreclosure. Well, the bottom line, what is it? The bottom line is the bottom line, and the boards need to make decisions as to whether you're going to move forward with this action and try and protect the interests of the association, or sit there and bleed to death. And there's no sure shot at any particular course of action. What is sure is that things are probably not going to get better in Florida for a long time, probably I would guess 18 months from today, which is February 6, 2009. So we're looking at the middle or end of 2010 before the market even stabilizes. And that doesn't say anything about the downward pressure on prices from the hundreds of thousands of foreclosures that are going to reset the whole market, which are going to cause people who have equity now to have no equity, and they might walk away from their homes, sending another round of defaults and foreclosures and so forth. So it's not a fun scene by any means, but it's just we have to make decisions and consider things that never even would have been thought of even a year ago. So watch my other videos on the issue of whether an association has to pay when it takes title subject to a mortgage. The answer is no. If an association takes title as a result of a foreclosure, you don't pay property taxes. You don't pay you really don't pay anything unless you have to, and you find a tenant for the least price, for the most price possible on a short-term lease. And those of you who've been who amended your documents 3 or 4 years ago because there were so many speculators leasing in there may want to take a look at your documents to see if it says the limitation on leasing also applies to the association, or if you remembered to be smart enough to say this provision does not apply to the association. Anyway, till next time, see ya.